Okay, so let's take a look at the second non-fatal offence against the person, and that's battery. And the image that I've put as the centrepiece here sort of highlights exactly what I mean between the difference between assault and battery, is that battery has become the touching offence, if you like. And the easiest way to think about that is to look at our non-fatal offences against the person pyramid. And you will remember and recall from the assault video that assault and battery sit at the bottom of that pyramid in terms of seriousness. Assault is the least serious of our non-fatal offences, and that's because it involves non-touching. Battery, on the other hand, slightly more serious because it involves touching. Now, that seriousness is only minimal because, of course, the maximum sentencing for both is the same. You'll recall also, I hope, that they collectively are known as common assault. And they're known as common assault because, unlike the other three offences, they are defined in the common law. Now, you'll also recall that Section 39 of the Criminal Justice Act gives them a statutory footing, and what it says is that they can be charged and recognised separately. You can be charged with assault, or you can be charged with battery. They are separate offences. I'm not going to go through the whole of the Criminal Justice Act statute. I'll allow you to go back to the video on assault just to get some idea about what we said there, should you want to do so. But what we need to do is consider what battery is and where it's defined in the common law. And battery in the common law is defined in the joint cases of Ireland and Burstow, 1997. You'll recall Ireland and Burstow, hopefully, from the video on assault. And in that case, in the appeal for that case actually, battery is defined as an act by which a person intentionally or recklessly inflicts unlawful personal violence on another. The definition, once again, is brilliant because it allows us to see very, very clearly what the mens rea is, and it allows us to see what the actus reus is. So when we are trying to prove criminal liability, whether that's in the normal course of law or whether that's in a substantive law question for our studies, first thing we have to do is to demonstrate clearly that the actus reus has happened, the act has happened, and that means that somebody has inflicted unlawful personal violence onto another. If we can demonstrate that that's happened, and we can demonstrate that the defendant did so either intentionally or recklessly, plus there is no defence, we have criminal liability. Again, I'm going to leave the complexity of a defence out of this video, and I'm just going to concentrate on what the actus reus is and what the mens rea is. But in short, if I can demonstrate that the defendant has inflicted unlawful personal violence on another, and then I can demonstrate that they did so intentionally or recklessly, I have criminal liability. Battery is a relatively straightforward offence. It only really has one key actus reus element, the infliction of unlawful personal violence on another. So it should be easier for us to work through. But the infliction of unlawful personal violence does give us a number of things to think about. The first thing that I want you to be very, very clear on is that infliction just means cause. Wherever you see infliction in battery, what you will be doing is applying the normal rules of causation, factual and legal causation. Unlawful is very similar to the framework set up in the video for assault. It means has the battery been done in self-defence? Has it been consented to? And if you want to use an unlawful piece of case law, once again you'll use Collins v Wilcock. And we're going to meet Collins v Wilcock on a number of occasions in this video, so we'll come back to that shortly. But when we talk about the infliction of unlawful personal violence, I want us to consider three things. That is the direct or indirect nature of the unlawful personal violence. The second thing is the notion of, is it consensual or is it non-consensual? Do we consent to it? Thirdly, I want to consider what we actually mean by physical contact. So let's start with these in terms. When we do, I do want us to recall that these are all things to discuss and consider in Actus Reus Element 1. All right, we're just delving deeper into that. The first thing I want to look at is whether or not the unlawful personal violence is of a direct nature, and in which case we're going to use the case of Collins v Wilcox, or whether it's indirect nature, and we're going to use the case of Hasted versus DPP. I have used Michael Jackson. He's got nothing to do with this, by the way. It was just a funny picture. But it's Hasted versus DPP, not Michael Jackson. You'll all recall, I hope, that the Collins v Wilcox case is the one where a police officer wants to speak to a prostitute. The prostitute refuses, and the police officer grabs the prostitute's arm. And the case revolves around whether or not the grabbing of the arm was lawful or unlawful. And of course we know that it's unlawful because the police wasn't intending to arrest the prostitute and therefore had no right to grab the arm. That's the facts of the case. We're just using it here to demonstrate that the touching of the arm, so the defendant touches the victim's arm. It's direct. The unlawful personal violence is direct. Defendant touches the victim. In terms of indirect, what that means is that the defendant touches a third person, and the third person touches the victim. The defendant is very likely still responsible for the harm to the victim, but indirectly. The personal violence has happened through a third person, so it is indirect personal violence. Both of these are sufficient to bring about liability. Direct and indirect are sufficient to bring about liability. I'm going to talk through Hasted in a moment, give a specific example, and then I want to look at the development of that through two cases that bring us to the current law. But the current law on indirect infliction of unlawful personal violence is Hasted versus DPP. In Hasted versus DPP, the defendant assaults, defendant hits mum. Mum essentially drops child. She's carrying it at the time. Child, the victim, hits head. The defendant is liable for the damage to the baby's head. My writing is dreadful on this, I appreciate that. The defendant assaults a child by punching the child's mother, causing the child to fall and hit his head. The defendant argues that the battery requires the direct application of force, i.e. he can only be found guilty if he himself hit the baby. The court says that's not the case. The court says the battery does not require the direct infliction of violence, and that Hasted's act had been comparable to using a weapon to cause the child to fall. Although Hasted had punched the complainant, the mother, and not the child, the punches had caused the child to be dropped, and therefore the magistrates in the court of first instance had been entitled to find the defendant guilty of assaulting the child. So that gives an indirect demonstration. Now Hasted comes about, and it is our current law, okay, so when we use it in examples, always go for Hasted versus DPP to demonstrate it. But it's just worth getting to grips with the case law that brings us there. R versus Martin, 1881, it's an old case. We're talking about an old theatre. And in this old theatre, what Martin does is that he places an iron bar across the exit as a joke. Ha ha. He turns the lights out and then yells, "Fire!" And of course, people are concerned that there might be a fire in the theatre. They get up and they run towards the exit. They can't get out of the exit because it's been barred by the iron bar, and many are injured. The judge clearly, in that case, clearly says that even though Martin did not physically assault or injure those people, the fact that he put a bar there and that the bar had prevented the doors from opening and the crush that ensued injured the people, Martin was responsible. He had caused, he had inflicted the injury indirectly. This is backed up further by the case of DPP versus K. It's a 1990 case, and you'll notice the use of the word K demonstrates that it's about a juvenile. Always use an initial when we talk about juveniles. And in DPP versus K, the defendant placed acid in a hot air dryer to hide it from the teachers. The victim uses the dryer and the acid burns the face of the victim. So you have the defendant puts the acid in dryer. Dryer spits, let's say spits acid onto victim. The defendant has caused indirectly the injury to the victim. All right, and that's done indirectly. Those two cases are confirmed completely in Haystead. Now, I know you only need to remember the Haystead case, but it's always interesting to talk about how we get to that point. On that issue, I just want you to consider the position on omissions. If you will recall from our discussion in terms of assault, is that generally it has to be an act, not an omission. But if you'll remember, the case of Santana Bermudez has changed that. In Santana Bermudez, a police officer asks somebody that they are about to search whether or not they have any needles or sharps in their pocket. Santana Bermudez says, no, they do not. The police officer puts their hand in Santana Bermudez's pocket and is pricked by a hypodermic syringe. The judge says that when they were asked and refused to state that there was or failed to state that there was a needle in their pocket, Santana Bermudez creates a dangerous situation. That creation of dangerous situation creates a duty to act. At that point, they should have informed the police officer that there was something sharp in their pocket. They failed to do so and therefore became liable for the injury. So, battery now, it seems, can be committed by an omission, but only if a duty to act can be found. All right? So, relatively straightforward. I just wanted you to be aware that that was the case. Let's look at our second element. Let's draw a line around that. Let's look at our second element, consensual or non-consensual. In essence, does somebody consent to the battery? And the general rule is that battery requires non-consensual touching. If you consent to it, then essentially there's no offence. We'll talk about that in a little greater depth when we look at the consent video. But essentially, battery requires that the touching is non-consensual. That can be express. And express means the victim agrees. Or alternatively, it could be implied. And by implied, it means that there's inevitable contact. Am I going to spell this right? Inevitable contact. And once again, guess what? The case that we use for this is Collins v. Wilcox. And Collins v. Wilcox is important here because the judge in that case, Lord Gough, makes it very, very clear. And I'll say what Gough says precisely, and then I'll give you an example of what I mean by that. Lord Gough says, consent is a defence to battery, and most of the physical contacts of ordinary life are not actionable because they are impliedly consented to by all who move in society and so expose themselves to the risk of bodily contact. It is more common nowadays to treat everybody jostling as falling within a general exception embracing all physical contact which is generally acceptable in the ordinary conduct of daily life. Now, never let it be said that if a judge can use one word, they use 40 words. But what Lord Gough means in that instance is that all of us in our day-to-day business, when we're on the tube, when we get on the bus, when we're walking through the corridors at school or university, except that we are going to be bumped and touched effectively. That is implied consent. I know that if I walk through school, that students and other teachers in the jostle of daily life are going to be touching me. They're going to be bumping arms with me. They're going to be bumping into me. That is implied consent. It happens. And the people that bump into me are not liable for battery. So that's the consensual can be either express, I agree to it. Sorry, that arrow should be there really, shouldn't it? Or it can be implied through the inevitable contact that everyday life brings to us. However, that everyday contact must not exceed the boundaries of normality. If, for instance, I slap my friend on the back to say hello and it's a light slap on the back, that would be normal, inevitable contact. If, however, I slap them on the back very, very hard and causing them to fall over, that would not be normal contact. So it's just worth bearing in mind. Now, what we need to look at now is the idea of what we mean by physical contact, what we mean by physical force, which is the third element that I want to talk about. And there must be some physical contact. So let's go, must be some. So there must be some physical contact, but the merest contact will suffice. The merest contact will be enough. Let's put that because it makes better, easier to understand. So the merest contact will be enough. In this instance, in R versus Thomas, that includes, rubbish photo, but I couldn't find one that fitted, touching the hem of somebody's skirt. So R versus Thomas is a 1985 case, and the defendant, who is a school caretaker, assaults a 12-year-old girl after taking hold of the hem of her skirt, physically touches her skirt. Doesn't touch her, touches her skirt. The court says that the act was not inherently indecent, and there was no evidence of circumstances making it so. So it's not an indecent assault at all. But the judge in that case, Lord Ackner, says that there can be no dispute that if you touch a person's clothes while they are wearing them, that is equivalent to touching them. Now, that was an obiter decision. It was something that the judge said outside of the actual the verdict. But what it means is that the merest contact will be sufficient to prove a battery. Stroking somebody's hair would fit that. Touching their clothes fits that. Again, we've talked about Collins v Wilcox, and I'm going to leave Collins v Wilcox really because that talks about the this notion of the inevitable contact. Yeah, the idea that jostling in a busy everyday street, a supermarket, an underground station, that's going to be normal contact. But what I want you to do is consider what we discussed about Collins and Wilcox and this idea of inevitable touching and compare it with Wilson v Pringle. In Wilson v Pringle, a schoolboy, in fun, seized the bag over the claimant's shoulder, causing him injury. The claimant sued for the tort of assault, so it's not a criminal case necessarily. The judges decided that the court must establish an intentional and hostile touching of one person to another. So a new use of the word hostile now. It doesn't have to be an intent to injure, but it does have to be hostile. A claimant who cannot prove hostility on the defendant's part is likely to fail, because in a crowded world, people must be considered to take upon themselves some risk of injury from the lawful acts of others. You may disagree with that, and you may suggest that actually in Wilson versus Pringle, that the snatching of the bag was sufficient. But once again, the court used the notion set up in Collins v Wilcox of this idea that everyday activity falls outside of the scope, And the word that they used to demonstrate what everyday activity was to ask yourself, is the touching hostile or not? If it's hostile, then you are much more likely to succeed in terms of battery. So those are our three elements. Our three elements are, if we remember, we go back over here. Is the unlawful personal violence direct or indirect? It doesn't matter, to be perfectly honest, because both direct and indirect will apply. Is it consensual or non-consensual? Because only non-consensual personal violence will be construed as a battery. And thirdly, what do we mean by physical contact? And we mean the merest touch, don't we? The merest touch and the merest hostile touch. Okay? So, better way to ask it is this the sort of thing I expect to happen to me in the normal course of daily life? Right, I want to introduce now another contentious element. I want to introduce you to the joint charging standards. The joint charging standards were something that were agreed by the police and the CPS and were produced in order to clarify the offences that would be charged with different levels of injury, i.e. what level of injury constitutes a battery, what constitutes ABH, and then when we get a bit further, what constitutes GBH. We'll look at those two later. The joint charging standards say that scratches and grazes, minor bruising, superficial cuts, black eyes are likely to fall within the boundaries of battery. Temporary loss of sensory function, multiple bruising, minor cuts that require stitching, minor fractures are all like to be ABH. Now, a word of warning please. I want you to use the joint charging standards to back up your decision, not to be the focus of it. Do not rely on the joint charging standards for offence recognition. The easiest way to do that is to consider the actus reus and, more importantly, the mens rea. What did the victim intend? What did the defendant intend and what actually happened? That will be the key driver for you in deciding whether or not it's a battery or an ABH. What you can then do is to look to the joint charging standards to confirm your decision. But just be aware that they exist. Just be aware that it's something that the police and the CPS use extensively. But for us as lawyers, I want us to consider the elements of criminal liability when we decide between battery and ABH or ABH and GBH. And finally, the last part is to look at the mens rea. The mens rea, like it is for assault, is relatively straightforward. This is a basic intent crime. And by a basic intent crime, of course, we mean it can be committed intentionally or recklessly using Cunningham subjective recklessness. The case that we use for that is Venner, R versus Venner, 1976. And what Venner says is that the mens rea for battery is intention or subjective recklessness to apply force to the person of another. Please do not say in your answers, when you're answering questions on this, the mens rea for battery is intention or subjective recklessness. It is intention or subjective recklessness as to applying force to the person of another. That force is either subjective reckless. The defendant must foresee a risk that the victim will will have force applied to them. And it's what he actually foresaw, because it's subjective, not what he objectively should have foreseen. Hope that makes sense. It is straightforward, and I don't want to get lost in translation. But in essence, the mens rea for battery, stated in Venner 1976, is that the intention or Cunningham style recklessness to apply force to the person of another. Just so as you're aware, Venner, the defendant struggles with a police officer who was arresting him. The defendant falls to the ground and lashes out wildly with his legs, fracturing a bone in the hand of an officer. And the courts say very clearly the offence of battery is satisfied by proof that the defendant intentionally or recklessly applied force to the person of another. So, straightforward, battery is one of the easiest offences that we will look at, and the only things to consider, as I've said earlier, are these three elements here about direct, indirect, consensual, non-consensual, consensual, and what we mean by physical contact exactly.